এডুকেশনাল ক্রিয়েটিভিটি চ্যানেলে সকলকে স্বাগত। আজ জানেন ওবিসি মামলা ছিল সুপ্রিম কোর্টে। সেখানে ৭ই জানুয়ারি নতুন ডেট পড়েছে ২০২৫ সালে, কিন্তু আপনারা লাইভ হিয়ারিং এখানে দেখতে পাবেন। তার আগে একটি কথা বলে রাখি যে কপিল সিব্বল এই মানে সবগুলি বিস্তারিত বলেন। ৪০ মিনিট ধরে শুনানিতে পর্যালোচনা করেন কোর্ট। এমনকি ওবিসির বিপক্ষে যারা আছেন তাদের দাবি ছিল যে কোনো সার্ভে না করে এই ওবিসি সার্টিফিকেট প্রদান করা হচ্ছে। সেই জন্য কোর্ট বলেছেন যে এই সার্ভে রিপোর্ট সম্পর্কিত বিস্তারিত তথ্য জমা দিতে হবে সুপ্রিম কোর্টে। দেখুন তার লাইভ হিয়ারিং।
This at the bottom of page 209. Yeah. The opinion and advice of the Commission is ordinarily binding on the state legislature under sections 9 and 11 of the Act of 1960, irrespective whether a request to look into over-inclusion or under-inclusion is made by citizens or body of state. The expression Government of West Bengal and Government in section 2F of the Act is then down to mean State of West Bengal in discharge of its legislative functions, having due regard to the reports of the Commission under the Act. Now, the next is important. The second part of section 2H of the Act, which reads, and I quote, and includes such classes as the state government may by notification in the official gazette specify from time to time is struck down. Because how can such an act, or such a provision be struck down? That the state has no power. When the recommendation
This will be contrary to Chennai.
exactly, it just cannot be struck down. They've struck it down.
You said because the commission did not do it.
The commission did it for commission did it.
So you said it was given to the university.
No, that's for sub-classification.
That's what is
The inclusion is done by the commission. Inclusion is done by the commission. Include such classes. The inclusion is done by the commission.
I say the provision of the act is
Yes. Kindly see the act says, Mother, this is very strange. It says 517 volume 2. List means list prepared by the government of West Bengal from time to time. And H is other backward classes shall mean such classes of citizens as specified in Schedule 1, other than Scheduled Class and Scheduled Tribes, and include such classes as the state government may by notification of the official gazette specify from time to time. Struck down. Commission recommends and be notified. Mother, how can this be struck down?
The power is executive. Yes.
We are not deferred with the commission, because whatever the commission has told us for inclusion, it's the act itself is struck down. The section itself is struck down. So this is completely wrong. Now, can you see the next? It says section 16 D is struck down since it empowers the state executive to amend any schedule of the Act of 2012, including Schedule 1. Consequently, the 37 classes included in the exercise under 16 are struck down from Schedule 1 of the Act. And C under 16 says the state government may by order published in the Gazette add to or amend or alter any schedule. That itself is struck down. If we do something at the instance of the commission and we alter it, it's struck down. The power is struck down. It's against the constitutional judgment. Schedules can be amended, but power is with the government, and the legislature has given that power. So that now see, but it's 5A. 5A of the Act, one second, let me read. Of 2012, which distributes the percentage of reservation in 10% and 7% to the sub-classified classes is struck down. Consequently, the sub-classified classes listed in the two categories, namely OBCA, OBCD, are struck down from the schedule. So the sub-classification is struck down. And what does 5A say? Subject to the other provisions of the Act, 10% of the vacancies shall be reserved for candidates belonging to other backward classes, donated as other backward classes category A. Category and 7% of the vacancies shall be reserved for candidates belonging to the other backward classes category B. Category of the other backward classes in this is structured. So I can't have a classification of other backward classes, which is contrary to the constitutional judgment. Which is why we said that this has been continuing since 2010, 2012, struck down in 2024. Benefits have been given to us over the years.
We have backward teaching backward.
And then when it was over the page at 211, G, the executive orders dated so and so, issued by the government of West Bengal, Backward classes, welfare department, subclassified 143 classes are struck down. And then the executive orders classifying, no, this is important. The executive, H is most important. The executive orders classifying 66 classes prior to 2010 are not interfered with since the same have not been challenged. These are the Hindu pillars classification of backward classes of Hindus. 66 pillars of them, they say we can't strike it down because nobody has challenged it. The same process is followed prior to, the process followed afterwards, whether it is struck down. Process followed prior to the same process is not struck down because it's not been challenged. I mean, this is bizarre. Therefore, constitutionally, ex facie, this High Court order has to be stayed with the greatest respect. And then 200, para 2,
Para 2 at?
because it's not challenged. This is the process is bad. So we strike down. So inclusion struck down, sub-classification.
Class J. Clause J.
Clause J, backward classes, welfare department of the state in the exercise of power under 11 shall in consultation with the commission place a report before the legislature with recommendations for inclusion of new classes or for exclusion of remaining survivors. Where's the question of legislature coming in here? This exercise is to be done with us. If the legislature were to do it, you will strike it down saying it has not gone to the backward class commission. If the backward class commission does it, you say it should be done by the legislature. And your lordships have deprecated the practice of the legislature deciding this because they have their own political considerations. So, brothers, with the greatest respect, it is my humble submission, brothers. Since
Clause K doesn't make any.
If the services of citizens from the 77 classes and 37 classes added in the exercise of section 16 struck down or already in the service of the state have already availed the benefit of reservation or succeeded shall not be affected by the reason of his judgment. That's this year onwards, brothers. We can't do anything. No reservation at all, brothers, in admissions, no reservation in employment, no reservation in promotion, no reservation in scholarship. So what kind of orders are these? I said promotion orders. So, brothers, with the greatest respect, it's fine, your lordship may list it anywhere, but some interim order has to be passed, brothers, to help us.
We'll hear it.
Yes,
I think that we'll hear it.
Yes, yes. Your lordship wanted a bird's eye view, brothers. I give it to you.
You must hear Mr. Patwali has already.
Yes, yes. There are so many solicitors. But they are very what
Yes. In any case, we are not hearing it today. So, unless if you want to say something.
On behalf of Commission, if I may just 2 minutes. One of the reasons given is that the Muslim counterparts, these that a barber who is Hindu is included, obviously. But a barber who is a Muslim, if he is sought to be included, that is said to be based on religion. And just this, I'll just read 2 paragraphs. He says, High Court says at page 174, there is a set of classes who once belonged to the Hindu religion. Page 174. And